This is the judgment summary in Bresco Electrical Services Limited in liquidation against Michael J. Lonsdale Limited. This appeal is about whether the modern process of adjudication of disputes can work where one of the parties to the dispute is in liquidation and there are cross-claims between the two parties. Construction adjudication is a highly successful form of alternative dispute resolution, which I'll call ADR, introduced as a statutory right in 1996 for the speedy settlement of disputes under construction. The dispute is submitted to an independent expert called the adjudicator, dealt with usually on paper rather than at a hearing, and produces an award which binds the parties unless and until one of them takes the matter to court. During that period, the award may be enforced by the successful party, and this gives effect to the pay now, argue later principle, which has proved to be highly beneficial in the construction industry generally, because it avoids project cash flow being held up by disputes. In fact, the vast majority of adjudication decisions are accepted by the parties as finally determining their dispute at a fraction of the time and cost in court. It is no exaggeration to say that adjudication has transformed the field of building dispute resolution, and almost everyone would say much for the better. There are, however, special procedures for the determination of the liabilities of a company, including a building firm, when it goes into insolvent liquidation. Generally speaking, claims in court against are prevented, or if they're already begun, stopped, and those with claims against the company send in proofs of debt, which are ruled upon by the liquidator, with a right for the creditor to go to court if dissatisfied with that ruling. But the liquidator is, in general, free to pursue the company's claims in proceedings, by ADR, or by any other available means, including adjudication, for the benefit of all the company's creditors. Sometimes there are cross-claims between the company in liquidation and another party. Then those cross-claims are netted off against each other in a process called insolvent set-off, leaving a net balance owed either to the company or to the other party. In the present case, Bresco, a building company, did work for Lonsdale under a construction contract which included an adjudication clause. Bresco went into liquidation, and the liquidator commenced an adjudication on behalf of Bresco against Lonsdale. Each company alleged that it was owed money by the other, but Lonsdale immediately went to the Technology and Construction Court, the TCC, for an injunction to stop the adjudication. Lonsdale said that adjudication could not be used by the liquidator of an insolvent company where there are cross-claims between it and the other party for two reasons. First, because the effect of insolvency set-off was to kill off the claim and therefore the dispute under the construction and replace it with a claim to a net balance in the liquidation. The adjudicator no longer had jurisdiction. Secondly, because the process of adjudication was inherently incompatible with the process of liquidation, in particular because an adjudication award could not be enforced as long as there remained a possibility of challenge to it. So an adjudication in such a situation would be an exercise in futility and a waste of time and money. The TCC agreed with both of those reasons and granted an injunction stopping the adjudication. The Court of Appeal disagreed with the first, the second, and therefore upheld the injunction. This court unanimously disagrees with both reasons, allows the appeal, and sets the injunction aside. I give the leading judgment, with which all my colleagues agree. Our reasons are, in summary, as follows. First, the existence of insolvency set-off does not mean that there is no longer a claim and therefore a dispute under the construction contract, which is the foundation for the jurisdiction of the adjudicator. For some purposes, such as assignment, A claim and a cross-claim affected by insolvency set-off lose their separate identity. They remain separate for other purposes, in particular for the purpose of resolving any dispute about them. Secondly, although there will be many cases where an adjudication award in a case affected by insolvency set-off may not be immediately enforceable, this does not mean that adjudication in such a situation will be an exercise in futility. In many cases, the adjudication award will be accepted by both parties as finally resolving the relevant dispute, leaving insolvency set-off as a mere matter of accounting. This is one of the purposes and great strengths of the adjudication process. Thirdly, and most importantly, adjudication of a dispute under a construction contract is a statutory and contractual right. It is accepted that it may generally be resorted to by, and nothing in the statutory schemes for adjudication for insolvency takes it away where there happen to be cross-claims qualifying insolvency set-off. It would therefore be a very exceptional case in which it would be appropriate for a court to restrain by injunction the exercise of that right by a liquidator.